getting involved in the very beginning of cases with them. And I want to encourage folks on this call and folks around the country to kind of do the same thing. And we're going to talk a little bit about that today. So the point of today is to improve your ability to effectively record evidence, also to effectively present that evidence, and to become more confident when testifying in court. Another quick polling question. I want to get an idea of how many of you in this audience, how many years have you been in your current profession? I know most of you are law enforcement officers, and so for me, I just want to get an idea of the level of experience.
And Jessica, the polling is now open again, folks. Your polling question is, how many years have you been in your current profession? Your options are 0 to 3, 4 to 6, 7 to 10, or more than 10. And we will give everybody just a few more seconds. Everybody's getting their votes in early, and I love it when you guys do that. Let's go ahead and close the polling and share the results. Jessica, we have a very, very seasoned audience today. 48% of the audience have been in their profession for more than 10 years.
Oh, wow.
26%.
Okay.
Now, interestingly, 26% of the audience have been with their profession for 0 to 3 years. So they're newbies. 16%,
okay.
7 to 10, and 11%, 4 to 6.
Okay, so that kind of helps me frame the discussion that we're going to have today. And for some of you, this may be very basic information. For some of you, this may be something that you have had experience with throughout your career, but it may be something that's a good reminder for you. And then for those of you who are new at this and have maybe never testified in court or had much experience with it, hopefully some of this information will be very helpful. So either way, I hope that it will either be new helpful information or information that will be a good reminder. We're first going to talk about case preparation. And when we're talking about case preparation, at the end of the day, no matter how well we prepare our case, what is it that is the most important thing overall? And the most important thing overall when it comes to criminal cases, criminal investigations, criminal prosecutions, is that the judge or the jury, whichever is the trier of fact at the end of the day, believes what you said. And we know that defense attorneys focus, if a case is going to go to trial, whether it be a bench trial in front of a judge or a jury trial in front of a jury, the defense attorney's focus is most likely going to be pretty much on you as law enforcement officers. Because law enforcement officers are the ones who typically, for the most part, are the ones who are going to be the key witness of a case. And they know that if they raise doubt about you, they're going to be able to start raising doubt about the entire case. So how is it that you can be believed? You can be believed with detailed case preparation, and that comes from your investigation and your report, and also prepared case presentation. And that comes from your courtroom testimony. And I think oftentimes when we are investigating cases, we're not necessarily responding to a crime scene thinking about the trial. But I want to encourage you to start thinking about responding to crime scenes when you initially get that call or you arrive on your scene as if that case is going to go to trial. Because from a defense attorney's perspective, they are going to be looking to pick apart everything you did from your initial arrival on the scene. One of the most important things for a police officer is obviously understanding the standards of proof in your laws. And since many of you on here have had a lot of experience, this is something that is very familiar to you. But for those of you that are new, it is very important to understand the difference between reasonable articulable suspicion, which usually occurs with a traffic stop, and that's when you just have reason to believe that someone is engaging in criminal activity, and know the difference between that and probable cause. Believing that an individual is has committed, or is about to commit a criminal act. An officer must be able to articulate facts that form the probable cause, and that's when details become so crucial. A lot of times when we talk about motions to suppress in criminal cases, the difference between getting past a probable cause argument or getting past a motion and not might have to do with simple little details. For example, on a DUI traffic stop, if we have weaving on the road and bloodshot, watery eyes, there's a very different between weaving on the road, bloodshot, watery eyes, smell of alcohol in the breath, and, field sobriety investigations, for example. So every little detail that you can add to your report and to your investigation about facts that you can articulate to form probable cause are really going to matter down the road. At trial, we know that prosecutors have to prove a case beyond a reasonable doubt, and obviously that is very different from probable cause. I encourage all of the police officers on here to understand that your job is not just to make probable cause or get to probable cause, because that's not going to get us where we need to be at the end of the day. The court process continues, the standard of proof gets higher, and in order for us to prove guilt beyond a reasonable doubt, we have to have enough evidence to prove something beyond a reasonable doubt. It's also very important to know the laws in your jurisdiction. Defense attorneys love to pick apart whether or not you understood what the law meant when you arrested somebody for a particular offense. And sometimes the way our laws are written, it will have pain and suffering in it. That does not mean that we have to prove pain and suffering. It means that we only have to prove pain or suffering. So we need to understand that sometimes our laws are written a certain way, but when it comes to how they are applied in the courtroom, it's something different. And it's important to understand the distinctions between those. One of the biggest questions I get from police officers is about anonymous complaints and how to handle them. And I want to talk a little bit about anonymous complaints because so often people want to make a report about criminal activity or suspicions of criminal activity that they're seeing, but they don't want anybody to know who they are. And the important thing about that is that we want to respond to all anonymous complaints because most of the time they are legitimate. We know that people fear retaliation from either the actual suspects themselves or maybe even the community in which they live in. So it's important and crucial to always respond to anonymous complaints, but to also let that individual know that if you as the police officer are not able to see the crime yourself, then it may be important down the road for them to have to come to court. We want to make sure, I'll just go back to this, we want to make sure also that if in fact a police officer can go and respond to a particular crime scene and see and observe the crime happening or the crime in progress themselves, that person certainly can remain anonymous down the road. In order for us to be able to prove guilt beyond a reasonable doubt or even to establish probable cause, we need somebody that can hear, see, smell, etc., whatever is going on. So sometimes anonymous complaints can be perfectly legitimate and perfectly appropriate, and they can remain anonymous. Other times we may need them to actually come to court and testify, and that's really going to depend on what the officer was able to see and not see. It's also very important for witnesses or potential witnesses that if you start conducting an investigation and you're not going to continue with that investigation, that you explain to them why. We want people to feel comfortable reporting crimes to you. And I think oftentimes people are fearful for reporting crimes because they think that nothing's going to happen. And so be sure that you're explaining to folks when they're taking their time and effort to explain or to call you about a crime, that you explain to them why an investigation is not going to proceed further. Witness preparation is definitely the key to having a successful case down the road. We know that witnesses' willingness to testify is often going to depend on their initial assessment of the arresting officer. Witness fears, like we talked about earlier, one of them, aside from being targeted by the suspect or others, is going to be a lengthy, costly involvement with the legal process. And sometimes it might take you, law enforcement officers, to explain to them that that's not really how it works, that oftentimes they won't be called to court, that only about 5% of cases actually go to trial. And even when they do go to trial, the chances of them having to spend very long times in court is not really the reality of the situation. I know for some of you officers it is, because that's what we do, but for the most part, the court process does not take that long for our typical witnesses. So if you don't mind just answering a quick polling question again for me, I'm interested to know the answer to this. I know the prosecutors in my jurisdiction and I work with them regularly.
And Jessica, the polling is open. We will give everybody just a few more seconds. Everybody's being great today about getting their responses in quickly. Again, the polling question is, I know my prosecutors in my jurisdiction and I work with them regularly. Your options are, on a scale of 1 to 4, strongly agree, agree, disagree, or strongly disagree. And we will go ahead and close the polling and share the results. A lot of folks agree with this proposition, Jessica. So 34% said strongly agree, 37% agree, only 21% said disagree, and even fewer, 7% said disagree, strongly disagree.
All right, that is great news. I could not be happier to hear that. I will tell you that a very quick story. When I very first started my career, I went to a conference, and at that conference, for whatever reason, the instructor it was a law enforcement / prosecutor conference. They separated the law enforcement officers and the prosecutors into 2 different parts of the room. And I think the whole purpose was for us to actually have a productive discussion about what we could do to help each other. And it turned into a big screaming match about what we did not do to help each other. And it was at that very point in time in my career that I decided that I was going to go out of my way to work very closely with my law enforcement officers and be as respectful as I possibly could of them about their time away from their families, the time that they did have to spend in court, the hard work and effort that they put into everything that was being done to investigate cases, and the security, obviously, risks that they deal with every day. And so I encourage any prosecutors who are watching this to know how important that is, not just for the cases as a whole, but for your relationships in your community as well. I think it is crucial that we spend a better job around the country of prosecutors and law enforcement working together from the very outset of cases. I encourage law enforcement to get to know the prosecutors in their jurisdiction if they don't already, especially those specialized prosecutors who may be handling certain cases. Also, it's so helpful when you're responding to crime scenes to know immediately who to call when you have issues like adult protective services needs for elderly or disabled adults, DFACS workers for child welfare issues, animal control for animal cases, code enforcement, your victim advocates and domestic violence shelters, mental health counselors, code enforcement, crime scene, your professional experts like maybe a veterinarian in an animal case, and your probation and parole officers. When we talk about responding to crime scenes, we know that a lot of times folks don't want to talk to the police. So it may be up to you to figure out who, what, where, why, and how when it comes to a criminal case. Do we have to have a motive? No, we don't have to have a motive, but it certainly helps when we're arguing a case to a jury to be able to talk about a particular motive. When you respond to a crime scene, you want to be sure to note important things like the time of day, weather, temperature, venue, the location of where it's occurring. And I think the most important thing on this slide for me is to be sure, law enforcement, that we are including all first responders and other witnesses' contact information in our report. I think the hardest thing for me when I handled multiple co-defendant murder cases and I had up to 100+ witnesses in a case, trying to sift through who all was out on a crime scene, including crime scene personnel, what ambulance personnel may have responded, things of that nature. So just be sure that your reports are detailing all first responders and other witnesses. When we talk about other witnesses as well, I think this is something I mentioned later on, but I'll go ahead and talk about it. We really want to be sure we're getting good contact information for folks, because a lot of times when we talk about dealing with criminal cases, our witnesses are oftentimes, unfortunately, very transient. They have burner phones. They don't live in the same place. They rent. They may live with somebody else and not even be on a lease. And so I encourage you to always think about getting grandma's phone number or somebody that they're related to that has a stable number, that's had a stable phone number and address for a number of years, and indicate that on your report. I can't tell you how crucial that is when you talk about a year to 2 years down the road when a case is going to trial and being able to easily locate that person. When we're on a crime scene, we want to be sure that we put in our reports not only what we see, hear, and smell, etc., but also what you don't see. That's oftentimes going to come up in certain cases where we should be seeing certain things, such as, many of you know, I prosecute or handled animal cruelty cases as a part of my duties as a prosecutor. And for example, when you talk about a case like that, we want to see proper food, water, and shelter on a crime scene. And if we don't, that's something we're going to want to indicate in our report. When you respond to a crime scene, you want to rope off the scene, map the crime scene, carefully package the evidence, and always establish from the very beginning your chain of custody. There's 5 main considerations when it comes to a crime scene. And again, this is obviously not a crime scene course or presentation today, so I'm just going to go over them from a very basic perspective. But I do want you to be familiar with things like talking about boundary determination, determining what is your boundary of your crime scene, whether or not that crime scene may have more than one location, if it's indoors or outdoors. Obviously, sometimes if it's outdoors, it's much more challenging to establish the perimeter, whether or not it's primary or secondary. An inside perimeter, when we talk about that, it means where the actual crime scene took place. And we want to make sure we get an outer perimeter, maintaining control of the entire crime scene from the exterior. We also are going to talk briefly about crime scene search patterns. Most of the time, it's either a spiral, strip line, grid, zone, quadrant, or pie wheel search. Most of the time, we're going to be dealing with strip line searches or grid searches. And I'm just going to show you a picture of those on this slide. I'm not going to go into a whole lot of detail on them, but just as an example, we want to figure out how we're going to map and mark our crime scene and how we're going to process the crime scene so that we're sure that we're doing it in an efficient and effective fashion. We want to be sure when we're on a crime scene that we delineate the responsibilities of everyone. There needs to be a point person in charge to ensure that everybody has a specific task and a role and that efforts are not duplicated. And we want to be sure we're talking to each other. About what evidence we're collecting, how we're collecting it, making sure that we're all staying on our particular task, because sometimes crime scenes can be very simple and not a whole lot of physical evidence, but then sometimes we can be talking about hundreds and hundreds of pieces of evidence that we have to collect. And if 1 or 2 of those pieces of evidence down the road aren't mapped, marked, and processed correctly, that can really harm a case. So it's really crucial that we know who's doing what, when, why, and how. Evidence collection, we need to think about what's not just what's visible, but what's not visible, and also what might be at the crime scene, but what might be elsewhere, and be sure that we're including those locations in our search warrants and that we know how to process those different things like cell phones for evidence. Social media, I will tell you, it's got to be one of the biggest go-to places these days to obtain evidence. A lot of times, for example, if somebody says, I've never been to that particular place, go look at their social media. Oftentimes there might be pictures of them there. I don't own that particular dog, for example, and there's pictures of them with the dog dating back 3 years ago. We want to make sure we're also avoiding any type of contamination, because any link, any break in the chain of custody or any type of potential contamination is obviously going to cause us problems when it comes to a jury trial. We want to be sure that we're packaging evidence in appropriate packaging. Some of you might have crime scene investigators that work very closely with your county or your city. Some of you might be a one-man show. And so especially for those of you who are in smaller jurisdictions who don't have the ability to have a crime scene technician come out or a whole team of crime scene folks to come out, we want to be sure that you're getting the appropriate containers and know how to properly store and label particular types of evidence so that it doesn't get contaminated. You want to be sure also that any type of evidence that's collected from the moment somebody picks it up from a crime scene or wherever they're picking it up from, that they're documenting it with the time and date that they touched it, etc., and that as soon as they pass it on to somebody else, that person is now filling out the same piece of paperwork about when they received it and when they may have passed it on to someone else. Here are just some quick pictures about some evidence that was collected from some of my cases. You want to make sure you label and date them appropriately. And like we said, know how to package your evidence. A lot of times we're going to want you to put evidence in paper bags for a whole host of reasons. But be sure, especially when you have things like multiple bullets and multiple guns and things like that, that you're documenting where each piece of evidence and each bullet came from and how it's related to each particular gun, etc. Statements, oftentimes very crucial to criminal cases. We want to be sure that anytime anybody is on a crime scene making spontaneous statements, that we're writing down exactly what they said and who said it. And then obviously when it comes to conducting a further investigation, try to take statements from your suspect when you can, and also any witnesses. And when you are taking those statements, we want to be sure they are either written, audio taped, or videotaped. Videotaped when possible. I know some jurisdictions have better access to some of these things, but do your best in your jurisdiction to make this a priority to have either an audio recorder or a video recorder when possible. It is highly effective when you have a person on video making their own statement versus you writing it in your police report, or having that particular person write their statement out in their own handwriting and sign it versus you putting it in your police report. I can't even begin to tell you how important photos and videos are. If you don't have crime scene technicians that are skilled at coming out to your crime scenes and taking photos and videos, take a class on it. Learn how to appropriately document evidence. I just want to show you the difference between how effective taking multiple photos can be. And for any of you who might be offended by, I guess, a kind of a, I'm not going to say gory picture, but kind of a very upsetting photo, you might want to turn your head away from the screen for a second. But this is a particular crime scene that we had where a particular person abandoned 2 dogs inside their property. Obviously, if I just got these 4 photos as a prosecutor, that's one thing. But then imagine if I was able to show these photos to a jury. Makes a huge difference. This is the same particular dog that you see in the bottom right-hand corner over here with his mouth literally in his food bowl as he was starving to death. But as you can see, these pictures are much more effective. So I just can't stress enough how taking photos from all sides and all angles and close up and you want to start from the very outside of your crime scene and take photographs moving in. And again, as you can see, the difference here between just taking photos of this same particular animal from different sides, it gives you a different perspective. So can't stress enough how important that is. Okay, so we're going to move into report writing. I think we probably don't spend enough time on report writing and how important it can be. But I will tell you that this is the very first impression most of your audience is going to get of a criminal case. Offense reports are the reports we talk about when we talk about a crime that occurred, injuries to persons or property. They are typically going to be your most detailed types of reports. There's also obviously incident reports, and that's when somebody calls out and makes a complaint, but doesn't necessarily mean that there's going to be a crime that occurred. Arrest reports may just detail why a particular person was arrested. You're obviously going to want to include any use of force information in that. And then, of course, you have your accident reports. Accident reports have got to be the most highly viewed reports when it comes to officer reports because of the fact that you usually have insurance companies involved, a civil suit involved as well. So there are probably 50 plus people looking at accidents reports on any given accident. Who's your audience for your police report? Well, first it's going to be your supervisor, potentially other officers in your jurisdiction, the judge, a prosecutor, a defense attorney, any witnesses or victims that want to do open records requests for the cases, potentially the media, and then you down the road when you're testifying in court. Some of you may only handle cases that are a very high profile, or you may be in a specialized unit and you may not deal with a crazy volume of cases, but I'm sure some of you deal with a whole lot of cases. And when you're talking about a trial a year plus down the road, oftentimes you're going to need your report to refresh your recollection about what it is that happened at that particular scene. So that's why I can't stress to you, not only is it crucial for your reports to be detailed and thorough and concise and accurate for yourself, but also for all of these other persons who are going to be looking at your report and judging your case and the criminal case as a whole, first and foremost, usually based on your report. I can't stress to you enough how important it is that your reports are clear and convincing, that they're truthful, you describe all of your observations accurately and truthfully, and that if you do have a time where you need to supplement your report, be sure that your reports are being supplemented by any follow-up investigations that you do or that a detective in your jurisdiction does, and be sure that that's indicated so that when people are pulling police reports on cases, they know that all of them go together. Field notes are a way that your police reports typically start out. So again, I know many of you probably this is very basic information to you, but you want to be sure that you figure out a way for you to take detailed case notes that you can later translate into very thorough police reports. This is an example to me of an officer-based report. So this is somebody who wanted to remain anonymous potentially. And you want to start out by saying, I was called out to the particular address, at what date you were called out there, what time you were called out there, concerning what the possible investigation was going to be. When you arrived out there, who you met with, what you saw or what that person told you. And then you wanted to start describing things as you're seeing them in order. As I arrived on the scene, I heard a dog yelping from the backyard. So again, you're describing what you're hearing before you're even talking about what you're seeing. And you're starting to paint the picture, not only for yourself about what's going on and any witnesses that might be looking at your police report, but for the jury down the road. Mr. Harris escorted me in the backyard where I saw the white male but very dirty mixed breed dog chained to a tree with a very large heavy chain around his neck. So you're starting to describe in detail what you're seeing, but then this goes even further. The chain was so heavy that the dog could barely lift its head. So as you can see, when you put that little bit of detailed information in there, the part that's underlined, it takes it kind of to a whole other level and paints the picture a little bit more. The dog also had a large mass on his back. I did not see any food or water bowls near the dog, nor did I see any shelter. So again, we're talking about not only what we see, but what we don't see. And you're starting to paint a picture that this animal is not being very well taken care of. Talk about the time and temperature, the heat index also. You can describe further the dog was panting and yelping as if he was in a lot of pain. So again, describing what you're seeing in detail. Knocked on the door to the residence, no one answered, and then you follow up with the witness stated he had not seen his neighbor at the house in 3 days. So you're also setting up here what in my jurisdiction is called an animal abandonment case, where somebody just leaves their animal tied up in the backyard to basically die, and you're kind of just setting up the description as to what's going on there. Organization in your police report is key. Again, it's going to be the first impression that somebody's going to get of you and what they're going to think of this case. One of the ways that I've found, I think, is the best way to organize a police report where you are not the main witness, where you are literally piecing together part of what everybody else is telling you they saw or heard, etc., is that you literally state, I, officer so-and-so, responded to this particular location, and then you put, my investigation revealed the following. That's a very easy way to kind of start out how to describe the order in which you were told things by other people, or in the order in which the crime, I'm sorry, not the order in which you were told things, the order in which the crime occurred. So, for example, Mr. Jones was working as a store clerk at the QT. He was standing behind the counter facing the store. There were no other people at the store. Like you said, the first few sentences are going to set the scene. The next sentence is going to talk about what happened. At approximately 12:05 hours, the suspect walked in the front door. And then the following sentence are merely going to state what happened next. So the suspect then walked around the store counter. He emerged from the back of the store, walked up to the counter, pointed the gun, and said, "Give me all the money in the register." So again, you're going to want to continuously make your police report read as the events were occurring. Once you finish telling the story, you can then add in the facts that were not brought up in necessarily a chronological order, like what evidence was collected, what pictures were taken, the statements that the witnesses gave you, any property that was recovered, and any other facts that need to be documented. In your reports, we should be using first person, not third person. I arrested Rob Pitts for armed robbery, not this undersigned officer. It just gets too wordy and is completely unnecessary. We want to be using past tense and active voice. So, for example, this report was written by Officer James. Anything that you talk about in your police report is going to have happened in the past. So use past tense. We talked about writing in order of the events that they happened. You also want to be sure that you're only putting facts in your police report and not opinions. And also, there's definitely no use for all caps. Just write as if you were writing normally. These are some of the examples that I often see get confused in police reports. So we want to be sure that we're using the proper verbiage, laying on the ground, not lying on the ground, for example. Another one is should have known versus should have known. That also applies to could have, would have, must have, etc. Two, and two. Obviously, the two twos that we see get mixed up most often are the first two. TO is a directive, meaning as in the direction of or toward, and TOO means also. So again, these are just kind of some of the typical things that I see that, you know, when we're in a rush and we're writing our police reports that we might get a little bit mixed up on, but they kind of become pretty critical to how you're observed down the road. We always want to be sure to check our spelling and check it again. These are a list of some of the, I think, top 50 plus words that we often see misspelled in police reports. And as you can see, many of these are ones that you're going to be using on a regular basis. So if you have any questions about spelling, pick up your phone, you know, just Google it. I have to do that often because I'm not a very good speller myself sometimes. So just make sure your spelling is correct. If you have missing information in your police report, what does that mean? Well, to a jury and to a judge and to a defense attorney, it means that it either didn't happen, you don't remember it, you're not very thorough, or you don't know what you're doing. So I can't stress enough how important it is for every bit of information that you want to talk about later on down the road about what you saw, smell, heard, etc., is in that police report. Not only that, we also want to be putting in our report what we did not do. And why is that important? Because you're going to get questioned about it. If there's follow-up investigation that should have been done or that you did, but it's not in your report, you're going to get questioned about it on the witness stand. So if you did do follow-up investigation with someone, but for example, you tried to make contact with them, but they were working nights and weren't able to speak with you, list that information in your report. It really, really, really goes to show how thorough you actually were being in investigating that particular situation. It may be that you are passing your report off to a detective. That detective who may be picking up your report later on to further investigate, it's also very helpful for you to, when you're passing your cases on to another law enforcement officer, for them to have that information in your report as well. When we're handing our files over, we want to have a number of things in our report that's going to, like I said, include any supplemental report, your citation, warrants, any records, an evidence list, and your chain of custody. Any statements, including the defendant's statements, and again, photos, crime scene photos that may have been taken of the defendant. Again, when we talk about taking photos, aside from crime scene photos, sometimes when we are booking defendants into the jail, we want to be sure we're taking photos of them of all angles as well. I can't tell you how many times that's come up as something crucial in a murder case or something that I had, that one particular the perpetrator had something in their hand or on their body in terms of clothing or something that another one did not, and just having a picture of that ended up being important to the case. So be sure we're taking pictures of everything. Make sure we're returning our search warrants and that we include the search warrant and return in our file. also any arrest, bond information, and special conditions. Okay, so courtroom presentation. Very quickly, how many times have you testified at a jury trial? A, never, B, 1 to 5 times, C, 6 to 10, or D, more than 10?
And Jessica, the polling is now open. Again, the question is, how many times have you testified at a jury trial? Never, 1 to 5 times, 6 to 10, or more than 10. We'll give everybody just a few more seconds. Thank you for being so responsive today, guys. This is wonderful. And we'll go ahead and close the polling and share the results. And Jessica, 53% of your audience has never testified at a jury trial.
Okay, so hopefully this is going to be some very helpful information for you if, in fact, a jury trial comes up. And like I said, we know that oftentimes we may not be called to testify at trial. About 5% of cases, if not less, of the criminal cases that you'll make throughout your career are going to end up in a trial. But those of you who may aspire to be in special units or who might be in special units, I will tell you most oftentimes cases that are going to go to trial are child cases, animal cases, homicide cases, anything where it's going to benefit the defendant to go to trial. In our murder cases, a lot of times we're asking for life. And if we're not reducing the case, it's kind of life or life. And then with, a lot of times with our child victim cases or our animal cases, people don't tend to want to be labeled as animal abusers or child abusers. So we see those cases go to trial a lot of times. I cannot stress to you enough how important courtroom testimony can be to a case. Because you can spend all of this time doing a bang-up job of investigating your case, documenting your evidence, writing an excellent report, and then you get to court, and all of that can go away very quickly. So when we talk about learning, I put that in quotation marks because it's just one of those things. I don't ever want a defense attorney to talk to you about whether or not you learned how to testify, but it's important to know all of the different components that go into testifying in court and why it is that this is probably going to be one of the most difficult tasks that you will face in your career. And that's because you are literally under a microscope when it comes to not only your credibility, but your conduct and your competency as well. When we're talking about jury trials, literally every single person who is sitting in that courtroom is going to be laser focused on you. And your reputation and your department's reputation can really hinge on courtroom testimony. We talked about this just a second ago, but all of this work that you do 1 to 2 years later down the road can essentially have meant not a whole lot if we can't get through the courtroom presentation part of a case. So I urge you to always have a conference with your prosecutor before trial. Discuss the weak points or problems of the case. You're going to want to make sure your prosecutors know when you don't know the answers to a certain question. Please ask your prosecutors. They may not come to you. You may have to go to them. And you may have to say, will you please go over with me what questions you're going to ask me and what tactics do you think the defense attorney is going to use or what questions the defense attorney may ask me. There is absolutely 100% nothing wrong with discussing the questions that are going to be asked of you at trial and what your answers are going to be. That's not in any way, shape, or form doing anything inappropriate. It is simply talking about the case and being sure that the prosecutor is on the same page as you. What I have found sometimes is that when you're not talking before court, sometimes things can get misinterpreted. A prosecutor can think that something in your case meant, or in your report meant something that it didn't. And the time that you're going to want to figure that out is not at trial. Because by the time you get to trial, the prosecutor should be 100% confident that that's where that case should be. That case should be at trial. You are confident you can prove this case beyond a reasonable doubt. You're confident of your evidence. You're confident of your witnesses. And so the time to find out things that might have been a problem with your case are not during trial. So talk about those things before trial. Be sure that your resume or your CV is current and you know it well. And be sure that you discuss your credentials, qualifications, experience, training, etc. with the prosecutor. be sure that before you start your direct examination that they are talking with you about your training and experience, especially those of you who have, you have to get your post hours a lot of times. You're getting a lot of training that you're probably not talking about on the witness stand. And one of the things that we want to do before you even start talking about a case is we want to build up your credibility on the witness stand. We want to talk about why it is that they should believe what is going to be coming out of your mouth. And why it is they should believe you has to do with your training and experience. Police officers, you all experience and face a part of society that many people do not. And so it is very important that you understand to them all of the training and experience that you have that leads you to believe why you make certain decisions. Because these decisions that you're making from the very outset of a case, you're making these split-second decisions that are then picked apart beyond belief inside of a courtroom where the process can be slowed down a lot. So you want to spend time talking about why it is that you did what you did, your experience that leads you to do what you did, and why it is that you have the ability to make those decisions. You want to get to court on time, be early. Some of you might be in charge, especially if you prosecute some of your own cases. I know some jurisdictions have courts that expect that in certain circumstances. Be sure you and your witnesses know where they're going and what's expected of them. When you're in the hallway getting ready for trial or getting ready for a motion, be sure you're not talking about the case because you might have a potential juror that's standing beside you. When you're in a courtroom, you want to make sure that you're wearing your uniform. Those of you who are detectives, be sure that you're putting your badge on or something to indicate that you're law enforcement. It really does make a difference to a jury if you're in your uniform or wearing your badge as a detective, or if you just walk in plain clothes as if, you just came from a restaurant on a family outing. We want to be using professional attire at all times in the courtroom. Be prepared that when you walk into that courtroom, that every single person's eyes in that courtroom are going to be on you. And it can be a very nerve-wracking thing, for sure. Just walk in with confidence. People laugh at me, but I used to kind of have a theme song, the Eye of the Tiger song, before I tried a case. And I just kind of got in a certain mindset where I had to have confidence in myself going in there, presenting a case to a jury. I knew that with my murder cases, I knew victims' families had been waiting days, hours, weeks, months, years for this process to finally happen, for that day for them to finally have in court. And so when you open that door and you walk in that courtroom, you want to start with having confidence in yourself and in your case. And by the time a case gets to a jury trial, trust me, we should know that we are confident we can prove that case beyond a reasonable doubt and that that's where we should be. So don't avoid eye contact with judge or with the potential jurors. Be confident. When you take the oath, be confident. You're going to sit down and the first thing somebody is going to do is have you put your hand up and say, do you swear to tell the truth, the whole truth, and nothing but the truth? And when your response to that should be concise, to the point, I do. Look at the person that's saying it or look directly at the jury and be very confident about the oath that you are taking to tell the jury the truth. When you're in the courtroom, if you happen to be in there when proceedings are going on, either before or after a trial, don't talk to each other when court is in session. When a judge is sitting up there very high on a bench, they can see everything that's going on in that courtroom. And you don't want the judge to have any negative emotions towards you at all. When you're speaking on the witness stand, you want to be sure that the farthest juror away from you can hear you. Usually a prosecutor will hopefully speak up if they think that you're not able to, if you're not projecting your voice loudly enough. But oftentimes a juror may not put their hand up and say that they didn't hear you. And that's not something that we want to hear after the case is over with, of a juror sitting there saying, well, I couldn't hear what that person was saying. So be sure that you're speaking loudly and clearly. Always use your honor when addressing the judge. Direct testimony, that's the easy part. That's when a prosecutor has you up on the witness stand. They're talking again about your credentials, your training, your experience, all those good things that we get you to talk about before your testimony. And then you get to start establishing the facts of the case. You don't want to be volunteering any information, only what's asked of you, and that goes for direct testimony and for cross-examination. Oftentimes, especially with prosecutors, we're going to have a certain way that we want the testimony to come out so that it makes sense to a jurors and that it's clear. So just try to stay focused on only what's asked of you. Don't use police lingo on the stand. Don't use it in your report. Don't use it on the stand. Try to just get rid of it in totality if you happen to use it. I don't know why this happens, but and I think us prosecutors do it too, but we want to use language that makes things sound more difficult than we need to be. We don't want to use words like, resulting in apprehension. And, you can see my first example there. Perpetrator exited the southeast door of the motor vehicle and started flight with responding officers in pursuit, resulting in apprehension. No. Just say at 9:30, the defendant got out of his car from the passenger side and ran, but was caught and chased by other officers. Much easier, much cleaner, much more understandable by the average person. Hearsay. Oftentimes we get very confused about what this actually means. But if you didn't see it, hear it, smell it, witness it, whatever, we have to have somebody come in to talk about it. Oftentimes we have people out on a crime scene that may have done particular things with the case. We need to make sure those persons are coming into court and testifying. You're not going to be able to testify about what another officer did or what another witness did. We need to make sure that they're listed in the report so that we can be sure they're in court to testify as well. Again, the judge's boss, you've got to be prepared for anything. Some of them are very different in how they run their courtrooms. Sometimes you might have, for example, an motions hearing, a very detailed explanation, well-prepared practice presentation, and sometimes they might cut you off. So you kind of have to be prepared to go with the flow, be respectful of the judge at all times, but also be sure that the judge fully understands what it is that you need to get them to understand. And sometimes you might have to push back just a little bit to make sure the judge gets the information from you, but again, be respectful about it. Go ahead and get in your head. We always have to prove ID and venue. If we don't prove ID and venue in a case, it can get thrown out. So one of the first things you're going to want to do is make sure that when you're testifying, you can identify the defendant and the county where the crime occurred. We need to also only prove the elements of the offense. So whatever the language is in the statute. We don't have to prove whether or not the sky was gray or blue that day, but we do have to prove what the elements are that are contained in that particular statute. And this is what we have to prove beyond a reasonable doubt. I'm going to actually, Chris, in the interest of time, I'm going to skip over this if you don't mind.
No problem.
What I want to get at here is that this is how crucial communication to the jury can be. If you haven't heard of this rule already, I've seen it different percentages. I've seen 7 to 10%. But what's so important about this is understanding this rule, that about 55% of an officer's appearance or body language is how a jury is going to interpret your communication to them. About 38% of it is how you speak and your tone and inflection, your demeanor, and only 7% is actually what you say. Every time I talk about this, it always amazes me to think that the majority of what somebody is judging us on has to do with our body language and how we're saying it and not what we're saying. So I can't stress to you enough why that's so important and why your attitude, your preparation, your appearance, and things like that are so crucial. Because this is not having those things, having a bad attitude or arrogance or hostility or not being prepared, etc., are what can cause you as a witness to fail much more than what you're actually saying. We want to be consistent with what we're saying, and is how you act consistent with what you're saying, and also when you're not saying anything. Respectfulness to the judge and jurors. When you come across as arrogant, people tend to just not want to believe what you have to say. One of the crazy things is our jury instructions actually read to the jury. So when at the end of the case, A judge reads what we call jury instructions to the jury, and that's the information they get before they're sent out into the jury room to discuss guilt or not guilty in a criminal case. And we have most of our pattern jury instructions actually tell the jurors, you should consider the witness's manner, behavior, and attitude, et cetera, in deciding the witness's credibility. Amazing. So not only do we know that this is how jurors are going to interpret whether or not they believe you or whether or not what you're saying is true, we also know that the judge is going to tell them that they can consider that. So the defense attorney. I know a lot of us get frustrated by defense attorneys. I want to say that what I want you to get out of this is that they are just doing their job. Our United States Supreme Court has even told them that they are under no obligation to present the truth. They are under no obligation to worry about the truth when they're in a courtroom. And so, you know, this is a funny little cartoon that I always like to share. I thought I was guilty until my lawyer straightened me out on that. Well, again, we know that cross-examination is their time to shine. That's when they're going to come in there and they're going to do their best to try to tear apart every good stuff about the case that's been put out there. And I can't tell you how much it's important to treat the defense attorney the same way that you treated your prosecutor. You want to maintain professionalism with them the same way that you did with your prosecutor. And if you don't know the answer to something, you just say you don't know. Oftentimes, defense attorneys will reach out to you, law enforcement, and they will try to get you to talk to them before trial. You are not under any obligation to do so. And if a if a defense attorney does reach out to you before trial and wants to talk to you, contact your prosecutor and have them there. There's no harm in that. I have worked with some very quote unquote good, I will call it, defense attorneys who are going to purposely try to get you to say something that is going to end up coming out at trial. And as a prosecutor, I don't want to find out that you and the defense attorney had this big long discussion about the case and I didn't know anything about it. Because I can do my best to try to be sure what they're asking you is appropriate and they're not trying to turn around what you're saying or twist around what you're saying if I'm there when they're talking to you. Oftentimes, I would invite the defense attorney over to my office with the prosecutor and with all the evidence laid out on the table and let them ask whatever questions they wanted to ask at that time, let them look at whatever evidence they wanted to look at that time. And that way there was just no issue in court as to any previous conversation. Just know that they are going to be doing and saying and asking questions to challenge your observations, interpretations, credentials, and credibility. That's what they are trained to do. Don't ask the judge if you have to answer a particular question. Just answer it. And again, talk about your training and experience. They're going to put everybody else on trial but you. Everybody else on trial but the defendant. They're going to put you on trial. They're going to attack you personally if they can. They're going to attack you professionally if they can. You just cannot let it shake you. They're going to mischaracterize training that you may have done by talking about how you may have been trained to sound believable on the stand. Just know how to answer that. Know how to distinguish training that you've had to testify professionally, and just talking about how you've learned how to present information and logically and concisely within the parameters of courtroom rules. Don't let them trip you up on this stuff. Demanding yes or no answers. Don't let them pigeonhole you into that if something needs explanation. And if it does, you simply just tell the judge, Your Honor, I need to further explain my answer to comply with the oath that I took, and so that the jury fully understands what it is I'm saying. And if a defense attorney keeps on with you about it, you say the same thing to the defense attorney. Sir, ma'am, I really need some more explanation to fully explain what you just asked me. And if they then try to cut you off and shut you down, they're the ones that just look like they're hiding something. They might talk about you getting paid if your court time is off-duty times. Again, don't let them trip you up on that. You just talk about how you're getting paid overtime just as if you were doing anything outside of courtroom testimony as well. They will try to ask you repetitive questions. Your response just needs to be, I've already answered that question, but just be respectful. Have you spoken to the prosecutor before court? They like to ask that because they know we're going to talk. Just simply say, yes, what we did was we talked about, what questions were going to be asked and, what issues we might need to address, and just be honest. You don't like the defendant, do you? Or sometimes they may ask you that. Again, just know how to respond to these questions. You don't say, no, I don't like the defendant. You can just simply say, I don't know the defendant. I simply just, arrested him for such and such, and I'm here today to talk about it. When they ask you why you are here, keep in mind that you're not here to convict the defendant. That's the jury's job. You're simply there to testify about what you saw, heard, smelled, and what your investigation uncovered. Don't say I think or believe or in my opinion, only state facts. And we don't want to be talking about polygraphs or prior criminal records unless you're permitted to do so. Just remember, again, defense attorneys are not the enemy. They're just doing their job, and don't lose your temper with them. From this point moving forward, this is how I want you to approach them. Literally, when a defense attorney announces ready for trial, you basically want to say cheers. Game on, I'm ready, I'm confident in my case, I'm confident in my investigation, and let's do this. So, again, if anybody has any questions, I think I'm only like a minute over. I am available for any of you. If there's anything that I can do for you to help you prepare for trial or to help you make your cases better, please let me know. This is my email address down here. This is my phone number. Also, if you're on LinkedIn, which I highly suggest getting on LinkedIn if you're not. I know the Justice Clearinghouse folks are on there as well. I'm on LinkedIn. Please connect with me. Please let me know what I can do to help you. And best of luck to all of you, law enforcement officers and you other folks. Please stay safe out there. And thank you for all that you do.
Jessica, what a fabulous job. I think you have definitely provided the framework for people to use as they're kind of thinking through how to prepare for trial, how to prepare for testimony, and all that good stuff. I know this could be a multi-part webinar series. You did such a good job of cramming so much information into the webinar in a short amount of time, so I really appreciate you doing this. And folks, just to let you know, Jessica will be back on December 13th to present Animal Cruelty Investigations and Prosecutions. You can find this webinar as well as so many other great topics on our law enforcement and our animal abuse feature pages, as well as our full calendar of events. Links to these pages are all in the GoToWebinar chat area, so be sure to check that out because we have still a continuing and growing list of upcoming webinars and topics and speakers that we just absolutely love to have you join us. Jessica, are you ready to take some questions?
Sure.
Absolutely. We've got quite a few. So you mentioned that only roughly 5% of cases actually go to trial. What's that typical time of window that can pass between the time of the incident and the point when this trial is actually starting? I mean, is it years? Is it months? What's that typical window?
Well, it's going to depend, number one, on the type of case it is, the jurisdiction that you're in. For the most part, traffic cases, misdemeanor cases, I would say I used to work in a very big jurisdiction, and I would say even then we had misdemeanor cases going to trial between 6 months and a year. I would say with felonies, you're looking more at a year to a year and a half to even maybe 2 years. And it seems weird when you say there's only 5% of cases that go to trial, but oftentimes once somebody is arrested, there's a lot of further investigation that may go into a case. There's also a lot of legal issues that may have to be hashed out in court before a case goes to trial. So oftentimes that's something that lengthens the process as well. But, typically we see anywhere from a year to 2 years. Some less, some more.
Got it. Perfect. Thank you. Next question. You spent some time, good advice, by the way. You spent some time, though, talking about spelling. And the question is, granted, spelling is important in school, but you made a point of this importance in the report writing section. Why does spelling matter quite so critically in a report? Does it affect something? What's the role that you were getting at with that?
So every single thing that's in your report, from grammar to spelling to anything that somebody is going to read your report, is going to look at that report, and it's going to be the way that they judge you as a police officer in terms of, is this person competent? Is this person thorough? Does this person check for, do they follow up with things? And so if they feel like you didn't read back through your report and realize that you had, several misspellings in there, it's going to cause them to initially view you in a different manner than they would if your report did not have typos and spelling errors in them and incorrect grammar. Am I saying that it's the end of the world? Certainly not. And if there's one little typo, those things do obviously happen. I'm talking about more in terms of just reading back through your report and making sure that there's not mistakes in there that easily could have been corrected. Because like I said, your report is going to be the way that the entire criminal case is judged from a lot of people at the outset. And so I think a lot of times we aren't putting enough credence, or we're not thinking about our reports as being as critical as they actually might be when the case is moving through the system.
Got it. Excellent. Thank you. Do you, or maybe we should say, did you as a prosecutor typically practice or rehearse testimony with witnesses? Did you rehearse certain questions, or how did you handle things as a prosecutor?
Yes, and I hate to use the word rehearse, but I understand what the question is getting at. Certainly. I would meet with my witnesses prior to trial, hopefully in person, and I would go over with them just like we were trying the case. I would ask the question, they would answer the question. I would ask the question, they would answer the question. And then I would also, sometimes when asked and sometimes when I thought that it was needed, I might do a mock cross-examination with a police officer or a lay witness to try to get them to understand what type of questions they may be getting from a defense attorney about a case. Sometimes it may have been that we weren't necessarily doing it with a particular case, but a lot of times when we do training, we do mock situations where we have somebody write a report and then we question them. We do a mock cross-examination off of those reports, because the time to learn how defense attorneys are going to ask you questions and the time to learn how to kind of handle those types of questions is not going to be when you're in the middle of a murder trial. It's going to be outside of a courtroom setting where you can get comfortable with learning what tactics they're going to use to try to confuse you or trip you up or make you look bad or whatever. So yes, I think doing that prior to trial is extremely important. And again, it's certainly not a matter of getting your testimony right. It's a matter of telling the truth, but understanding how it is that this might play out in a courtroom and making sure that you're able to competently and effectively tell the truth. And that's how you respond to it also if you ever get questioned about it.
Excellent. And we've actually got several follow-up questions here that have come in and well, as you were talking, so this is great. Next question. How much is there such a thing as too much preparation? Can you really practice too much, or do you end up sounding rehearsed? What's your experience?
Yeah, I certainly do not think you should practice to the point that you're sounding rehearsed, and I don't mean to say that at all. I just mean that I think it's important to discuss your case ahead of time, to know what questions you're going to be asked and to be sure you know the answer to them. Because if I am asking a particular witness, and I find this a lot of times, especially with my expert witnesses, and by that I mean, let's say it was a veterinarian I had that performed a necropsy on an animal, on animal cruelty case, and it may be that I'm asking them questions and it may be I did not understand their report. There was something in their report, and so prior to trial, if I'm saying, okay, well, these are the questions I'm going to ask you, they may respond to me and say, well, that's not what that means. And then for me, I'm able to say, oh, okay, so I'm completely asking that the wrong way. And they'll say, yes, this is what this means, and this is probably how you should ask me that question so that I can give you the best answer. It certainly does not mean by any means to literally rehearse word for word what you're going to say. So no, that's not what I'm saying at all.
No, perfect. Excellent. Next question, again, tagging onto the same vein and line of thought. Do you have any suggestions on how to get over the butterflies right before court?
Take a deep breath. Like I said, get a fight song. Mine was Eye of the Tiger. Still listen to it, still love it. I would just kind of get in my zone. I will tell you, I tried cases and lived in a courtroom for over 10 years, and it's still a nerve-wracking place for me, even after all of those years. And I'm comfortable in a courtroom. So I just say, you've just got to believe in yourself. You know that case better than anyone. And just say that to yourself before you go up on the witness stand. This is my time to shine. This is my time to tell these jurors or this judge what it is I saw, heard, smelled, or whatever. And just, like I said, take a deep breath and know that you can do it.
Excellent. Actually, we just had one of our audience members write in about using tactical breathing. Talk about putting your police training to good use here. How about using tactical breathing to avoid the courtroom jitters? What a great idea. I'm so glad you wrote in and suggested that. That's a great idea. Next question. Again, we're continuing on this line of thought. Go ahead.
Well, I was going to say, I did see somebody mention one time about taking a Q-tip with you and holding on to the Q-tip or something underneath the witness stand, and the QTIP stood for something. It was like, well, I'm not even going to try to remember what it was, but anything like that. Take something in that you could hold in your hand. You want to make sure it's not something you're jingling in your pocket or something like that. But just think about what might work for you, whether it be a breathing technique or holding something in your pocket or, I don't know, something. But I think for everybody it's probably different. But
good
just,
idea.
Trying to maintain that confidence in yourself.
Perfect. Next question, again, we're continuing on the same vein of thought. If we find ourselves getting angry at the questions from the defense counsel, what are some acceptable ways to maybe slow the question down, or how do you control that so you can respond calmly? Any advice?
So I think the best way to think about this is that their job, defense attorney's job, is to go in there and make you look bad. So their job is to rile you up. Their job is to make you get agitated. Their job is to do that. And if you just get in that mindset and understand, okay, who's going to win this battle, me or him? What does it mean for him to win? What it means for him or her to win is to get you riled up. What does it mean for you to win? For you to win, it means for you to remain calm no matter how much of a jerk they're being, or no matter how much they're trying to rile you up, that you sit there and remain calm, cool and collected, then you win. And I don't mean to phrase it like that, because the whole thing is not a matter of winning or losing, but it's the easiest way that I can put it into perspective. And that you just have to get in that mindset that you're going to win the battle, you're going to also win the war, and you're going to remain calm, because if you don't, then they win.
Got it. Excellent. Another question coming in. Again, folks, I'm trying to take your questions as quickly as they come in here. So along, again, the same vein, after the defense attorney or the prosecutor has asked a question, is it okay to take a breath, wait a second before answering a question? Yes.
It's okay to take a breath, to wait a second before answering your question. It's also okay to review your report and to ask, the judge for a minute to refresh your recollection. You don't ever want to look down at your report and read off of it, but you can certainly, if you need to take a breath, for example, even say, Judge, may I have a moment to look at my report to refresh my recollection? And sometimes you can do that even if you don't really need to look at your report, but you just kind of need to take a break for a second. But yes, you certainly can do whatever you need to do to try to maintain the integrity of what you're saying. So yeah.
And a follow-up to that, how do we say we don't know something or don't remember something without looking unprepared?
Well, let me just back up to that for 1 second, because what I do want to say is, and I should have mentioned this during the presentation, but reviewing your reports ahead of time, and this is why talking to a prosecutor ahead of time is so crucial, is because I have seen this. I have seen law enforcement, I've seen seasoned law enforcement officers come into a trial on a murder case, which is obviously pretty much one of the most serious cases that we can deal with, and having not prepared for the trial. And that goes off very badly and goes downhill very quickly. So there's two different parts of this. The not remembering, this is why it's important to write details in your report. Is it going to come up that sometimes you're not going to remember what happened at the scene? Yes, it's going to come up. And there may be times that you just forget to write it in your report, and you just have to be honest about it. If you didn't remember it, you don't remember it. If you didn't put it in your report, you didn't put it in your report. You're going to have to deal with those situations, but this is why we talk about this stuff ahead of time, because it is so important to put details in your report. It is so important to review your report before you go to trial. But it is what it is, and honesty is going to get you a lot further than anything else. And first and foremost, you have to be honest about whatever you're saying on that witness stand. And if you didn't remember it, you didn't remember it.
Excellent. Thank you. Next question. Can the original notes taken by a crime scene investigator or police officer, can that be requested by the court?
So for example, like the notes you're making out on the crime scene, I'm assuming?
I'm assuming so as well.
My guess would be probably. I think I remember that happening maybe in one of my cases in 10 plus years, somebody actually requesting that. A lot of times those field notes are long gone. I don't necessarily know if officers are required to keep up with them. I may not be the best person to ask about that. I'm sure that they can. I'll put it to you this way. At any point in time, a judge can ask for anything. I have had judges ask for strange things in my cases. So you just kind of never know. But I think the captains or sergeants at the police departments, they might have a better idea about what to anticipate with field notes. But a judge can certainly ask for anything at any time, so you need to be prepared for that.
Perfect. And last question. Do you have any advice or anything to say about Brady and Giglio decisions affecting officers' testimony?
Does the person give any more details about that?
That is all I have.
I have not looked at case law on that.